Welcome to The Explainer. Today, we're diving into a really critical question that sits right at the crossroads of your data rights and all those security cameras out there. It's a story about grainy footage, a surprising legal loophole, and what it all means for you. Let's get into it. Okay, so imagine this. An incident happens. Could be anything. A fender bender, a slip and fall. The only evidence? It's this super grainy security video where you're basically just a silhouette, a blurry shape in the background. So the big question is that image of you legally considered your personal data? You'd think you have a right to see it, right? But what happens when you ask and you're just flat out told no? This isn't just some hypothetical. It's a real problem, and it all comes down to a really controversial take on data privacy law. And trust me, the outcome here has major implications for all of us. So, to really get to the bottom of this, we first need to understand the rules of the game. Let's take a look at how the law, specifically Singapore's Personal Data Protection Act, or the PDPA, actually defines what personal data even is. Now, on the surface, that seems pretty simple, doesn't it? Personal data is any data that can be used to identify a person. But, the devil is in the details. The real meat is in how that identification can happen, and the law sets up this crucial two-part test. Okay, so the law gives us two ways to think about this. The first way is the obvious one. You look at a photo, you see a clear face, boom, that's you. But it's the second way where our story really gets interesting. It says you can also be identified by combining that blurry image with other information the organization has. And the law is crystal clear about this. It's right there in black and white. It explicitly includes other information to which the organization has or is likely to have access. This isn't some tiny footnote. It's a core part of the definition. And think about what that means. The time of day, the exact location of the camera, the incident report you filed, all of that is other information. So here's the bottom line. The law doesn't care if the camera is a brand new 4K model or some blurry old thing from the 90s. It doesn't care about pixel count. The only legal test is whether you are, by any reasonable means, identifiable. Period. Okay, so that's the rule book. But how does this actually play out when it hits the real world? Well, this isn't just theory. A specific ruling by Singapore's Data Protection Authority really brought this whole issue to a head. In this particular case, which involved a condo management, the authority looked at some footage of a silhouette and said, nope, not personal data. And their reasoning? They claimed the organization didn't have any other information to figure out who that person was. Which, immediately makes you go, wait a second. Of course they had other information. They own the camera, they know exactly where it is, they know what time the footage was recorded, and they got a request about a specific incident that happened at that exact time and place. And this, right here, is the heart of the problem. The ruling just seems to have completely ignored that second crucial part of the law, the part about using other information. It's like they judged the data purely on how blurry it was, and in doing so, created a really dangerous precedent. And this leads us to something pretty troubling, which experts are now calling the Graininess loophole. It's a direct and really worrying consequence of reading the law this narrowly. So what this creates is a really bizarre situation where your fundamental data rights could literally depend on the quality of a company's security camera. If the footage is blurry, even if everybody involved knows it's you, your rights could just disappear. So what does this actually mean in practice? Well, it creates this weird backwards incentive. An organization could almost be encouraged to use cheap, low-quality cameras. That way they only capture blurry figures, and then when something happens, they can just say, sorry, not personal data, deny you access, and dodge all their legal responsibilities. Now, this might sound like a pretty niche legal debate, but the real-world stakes here are incredibly high. What really happens if this loophole just becomes standard practice? Well, first off, your fundamental right to access your own data gets thrown out the window. Second, it actually encourages bad security. Why would you invest in good cameras if having bad ones gets you out of legal trouble? And third, it lets organizations completely sidestep accountability when something goes wrong on their watch. Critics argue this isn't just a simple mistake, but maybe a sign of a deeper issue. It suggests a mindset that's looking for excuses to dismiss a person's request, instead of upholding the spirit of a law that was designed to protect us in the first place. And that really leaves us with a final, powerful question to think about. In an age where we are surrounded by cameras, should your basic right to see footage of yourself be decided not by the law, but by the technical specs of the camera that happened to record you?